Good morning, everyone. I'm Jiuyang Zhou, the trademark attorney at Beijing CNIPA agency. The topic I'm going to share with you is registration examination and review strategies related to Article number 10 of the Chinese Trademark Law, also known as the Prohibition Clause. I will start with success rate in refusal review cases related to this article in the past 5 years, and then analyze these cases. Then I gathered some defense strategies which may be helpful to our further case handling. Article number 10 is one of the absolute grounds prohibits trademark registration in China. It has attracted much more attention than ever simply because it is widely applied in substantive examination and becomes extremely difficult to overcome in refusal review cases in both administrative procedure and litigation procedure. According to data source of Mo Zhilun and IP House, from 2020 to 2024, we could see a remarkable increase in refusal review cases. However, the success rate fell sharply from in the past 3 years, then stabilized below 10%. As for the administrative litigation procedure, we could see that there were some cases, though the sharp drop in both case number and success rate demonstrates restrictive force of the article number 10, and you may disregard the success rate for 2024 because the administrative case related to article 10 in this year was exceptionally low. And as you may know that the article number 10 consists of 2 paragraphs and a number of clauses. Thanks for the 2024 research panel on trademark compliance criteria, we could see an application rate of each clause or paragraph, and the proportion of cases based on misleading clause is high and continues to grow. Then comes the public order and morality clause, and the geographical clause ranks the third. Therefore, let's see how we will discuss how to overcome these 3 major refusal clauses in review cases. On this page, you could see legal provisions, judicial interpretations, and related rules and regulations around misleading clause. And in my view, the reasonings or opinions of judges are also important. It is held that a trademark application may fall under article under this misleading clause only if at least 3 elements are met. Number 1 is the logo contains words describing quality, raw material, function, and other characteristics of products. Number 2, it is easy to for the relevant public to associate the description of product characteristics with this designated goods, and the description is a misleading one. Number 3, the misleading description may lead to influence the purchasing decision of the relevant public. And in practice, some common scenarios may face a misleading article, misleading clause, and let's see how they overcome it. First one is trademark 万邦知识产权. It designates in services IP consultation and legal services in class 45. And examiners considered the trademark mislead relevant public about the purpose and content. However, the judges considered this trademark is a combination of company and industry field, and this industry field is related to the designated services. Therefore, the use of the applying trademark in its designated goods will not cause the public to misunderstand the purpose and the function of the services. The trademark number 2 is Nano Baby. It designates in goods, toys, etc. in class 28. And due to the containment of nano word, the examiners considered it may mislead consumers that the products can have nanotechnology that is quality or feature misleading. And the judges took into consideration about several key elements such as the fact of popularity of the brand in mainland China, its unique design, and prior registrations of trademarks containing nano as a part, or the general cognitive level and habits of the Chinese public. Overall, it is not easy for general public to understand the products have nanotechnology. Then comes the third trademark, that is Tech Star. It designates in industrial enzyme, etc. In class 1. The word text means plastic coating. However, the meaning of plastic coating is not popular among the relevant consumers. Therefore, the judges considered the trademark as a whole will not result in a misunderstanding of the product. The trademark number 4 is optoparisy. Because the trademark contains the letter composition Paris, the examiners considered it may mislead relevant consumers about the origin of goods. However, the trademark as a whole has no obvious meaning. Therefore, it will not make the relevant public have a wrong understanding of the origin of the commodities or other characteristics. Number 5 is 泰和音乐集团. It is not consistent with the applicant name, though the judges consider that the trademark there is no substantive difference between the applying trademark and the applicant's company name. Then let's move to the public order and morality clause. I put legal provisions, judicial interpretations, and related rules and regulations on this page for your reference. It regulates a trademark must not be detrimental to socialist morality or having any other adverse effect. And public view is also an important element to be considered. Let's see a number of cases facing this refused due to this clause and how they overcome it. The first group of trademarks contain 战火之初 and 猴子警长. They obtained recognition from official institutions to overcome this clause. As you may learn that 战火之初 is an online game, has obtained approval from National Press and Publication Administration for its legal operation. As for the 猴子警长, it is the name of a series of books and has been approved for publication by relevant national subject departments. And the second group contains Kasaya and Parsons trademarks. Both of the Kasaya has the meaning of China in ancient poem, and Parsons can be translated as parish priest. However, Chinese relevant public tends to view these two marks as meaningless and fabricated words. The third group of trademarks contain 牛商 and 安少爷. These two trademarks, in general, have no adverse effects. Therefore, the judges preliminary approve the registration of these two marks. The last group of trademarks, 智慧国立 and 殷新国艺馆, both of these trademarks contain 国. The Chinese character means national. However, both of the trademark as a whole or its element does not have any derogatory connotations. Therefore, the judges preliminary approve the registration of these two trademarks. Last but not least, let's come to the graphical names clause. It regulates that the name of any administrative division at or above the county level or the name of any foreign place known by the public may not be used as a trademark, except that the place name has other meanings. Therefore, the how to achieve the meaning other than place name is a breakthrough in refusal review cases. Let's see a number of examples. First group trademarks contain 盐津铺子 and 青岛 strong. Both of these trademarks contain place names. However, they acquired a second meaning by long-term extensive use. And the second one is Hampton Water. It has multiple meanings and is generally not directly associated with place names. To be specific, Hampton is not only a commonly used surname in English, but also a place name, and its popularity is not that much high, which is not widely known to the Chinese public. And the third trademark is 渝中继续. Although it contains 渝, the Chinese character stands for Chongqing City, a place name. However, the other parts, such as the Chinese character xu and the device part, domain the trademark. Therefore, the trademark as a whole obtained a second meaning that are different from the place name. The last group of trademarks contain 江苏园博园 and 河南省安装集团. Both of the trademarks contain place names. However, they are only part of business names, and therefore, ultimately, both trademarks obtain registration. That's all my sharing today. Thank you for your time.